Hi, this is Josh Blackman. I am the president of the Harlan Institute, and welcome to the 2021 Harlan Institute Virtual Supreme Court competition. This year, we're arguing the case of the New York State Rifle and Pistol Club versus Bruin, and this is match number 8 of the semifinal round. For petitioners, we have Elise Spenner and Audrey Young from Burlingame, California. And for respondents, we have from the Joel Barlow High School in Connecticut, Leighton Shore and Katie Katowski. All right, everyone ready to begin? Okay. Petitioners, begin whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Elise Spenner, and my co-counsel is Audrey Young. In September 2014, New York residents Robert Nash and Brandon Koch applied for concealed carry licenses to carry a firearm outside the home for self-defense. Nash cited recent robberies in his neighborhood and completed advanced firearm training courses, while Koch referenced completed safety training courses and extensive experience handling firearms. Both had no criminal history. Though Nash and Koch met the requirements for a license, New York officials denied both licenses for lack of a special need or proper cause. The two men and the New York State Rifle and Pistol Association, a gun rights advocacy group, sued Kevin P. Bruin, the superintendent of New York State Police, and Justice Richard McNally, a judge in New York's 3rd Judicial District. The district court dismissed their case, and the Second Circuit affirmed. The Second Circuit reasoned that their decision in Katowski, a comparable challenge to New York's public carry restrictions, contradicted petitioners' claims. This court granted certiorari.
Because New York's public carry regime restricts a fundamental right to carry arms for self-defense to those who show proper cause, the Sullivan Law is unconstitutional after consideration of text, history, and tradition, and under any level of heightened scrutiny. The ruling of the Second Circuit was gravely erroneous. The Second Amendment enshrined two distinct pre-existing rights: the right to keep arms and the right to bear them.
Okay, counsel, if I could jump in for a second. What exactly did Heller hold? What was the holding of Heller?
Heller held that the right to bear arms, keep and carry arms, is an individual right.
Okay. Did Heller say anything about carrying outside the home?
Heller cited cases that did uphold carrying arms outside the home, but it dealt specifically with carrying arms inside the home.
Okay, and this from Ms. Spenner. Does Heller resolve this case, or do we need to extend Heller and do some new stuff to rule for your client?
Well, Heller established that both the right to keep and bear arms were fundamental rights, stating that you could bear arms in the case of confrontation for self-defense. Thus, it seems a natural extension of Heller to assume that the right to carry is a fundamental right and cannot be subject to officials' discretion and to the atypical and requiring an atypical need to show that one can have that right to carry.
Okay, you can proceed, Counselor.
Bear, as defined by Samuel Johnson's 1773 dictionary, had the same meaning as to carry, as in the bearing of a coat, an activity which clearly occurred outside the home. Prior to the Bill of Rights, these liberties were assumed in the colonies. 1689 English Bill of Rights established the right to self-defense, and pre-founding laws...
Sure. I mean, the Bill of Rights said that, the English Bill of Rights said that, but isn't there older English law which prohibited the carry of arms in public spaces, specifically the Statute of Northampton? Could you address that?
Yes, the Statute of Northampton did prohibit the right to carry, but as clarified in Rex versus Sir John Knight, only with the intent to terrify. Thus, the Statute of Northampton was considered compatible with the English Bill of Rights, as it restricted the right to carry in certain situations, similar to surety laws, but did not, did not.
Do I take a sip of water? That's fine.
Restrict the right to carry.
Do I take a sip of water? That's fine. I can tell. Very good. Thank you, Counselor. Okay, Ms. Young, you can proceed.
Pre-founding laws restricted only sensitive places, dangerous weapons, and carrying specifically with the intent to terrify, as shown in the Statute of Northampton.
Why is history relevant to interpreting the Second Amendment today?
History is relevant because in order to determine how the Second Amendment should be interpreted, we must see first what influenced the founding fathers when they enshrined our rights, and second, how this was interpreted in the era directly following the founding era and also potentially following Reconstruction era after the establishment of the 14th Amendment.
Yeah,
Right.
but what, go ahead, go ahead.
No, just Krill, you go first. Go ahead.
Why do we care what a bunch of old dead men think about a document when we have statistics today about gun violence we can look to? What does that matter? History.
We care because in order for our rights to be solidified, in order for us to know that we do have rights, we do have to have a set standard, which was established by the founding era, by the Bill of Rights.
Well, let's maybe change gears a bit. You mentioned, this is Miss Benner. You mentioned sensitive places. How do you define this phrase, sensitive places?
Well, the term sensitive places assumes that there are areas that are dense where the need for public safety is heightened. We think about First Amendment and time, place, and manner restrictions on when that right may be expressed. There could be a similar regulation for Second Amendment rights in that the right is assumed, but is restricted in certain places where it's considered especially dangerous to express those rights.
So give me an example of a sensitive place. What do you think a valid sensitive place might be?
A school zone, a longstanding prohibition on the right to carry in a school zone would be a sensitive place because school children are especially at risk.
What about a college campus in New York?
Yes, a college campus could also be considered a sensitive place. It is densely populated and there's a heightened risk to public safety.
What about the subway in New York City?
No, the subway in New York City is a place where people regularly interact. It's part of one's daily life, not getting from this.
But kids ride the subway. They're allowed to.
Yes, Your Honor. However, schools could be separated from the subway because it is a place exclusively for students and a learning environment where the right to carry could be prohibited.
All right, Yankee Stadium, where 60,000 people watch a baseball game. Would that be a sensitive place?
Well, Yankee Stadium, Your Honor, would largely be would be private and restricted and has different regulations because it is a private. But I think, yes, if there was a demonstrated need to protect the public safety, it would be decided on a case-by-case basis. Okay. And I think New York Stadium could fit the bill.
All right, so let me change gears a bit. So what standard review do you think governs the Second Amendment for Miss Young?
Because the Second Amendment is a fundamental enumerated right, we suggest that the court use strict scrutiny when applying, when interpreting.
Did Heller say strict scrutiny governs these sorts of cases?
I believe so. And is held by
did Heller say strict scrutiny or heightened scrutiny?
Heightened scrutiny. Heightened
scrutiny. What's the difference between strict and heightened scrutiny?
I believe it may mean that the law must be narrowly tailored as held by First Amendment case law, like McCutcheon and Packingham, which held that even if intermediate scrutiny should be applied, it must be narrowly tailored.
Okay. All right. Well, then let me ask a question for Ms. Benner, if I can, for a minute. Let's say that we agree with you that strict scrutiny applies. Would the good cause standard survive strict scrutiny?
No, the good cause standard would not survive strict scrutiny. Strict scrutiny requires both a legitimate government interest and being narrowly tailored to that interest. The good cause requirement is inherently not narrowly tailored because it applies to far more people than is necessary to protect a legitimate interest in public safety. Baldia, Bernstein, all have described, Milo, all have described that even carrying cash in a high crime area is not enough to satisfy a proper cause requirement. Thus, we see that this is not narrowly tailored and that even people like Nash and Koch, who have shown a legitimate need to carry and have gone...
Let's take a step back, though. I mean, who gets to decide these questions, right? We're judges. We're not elected. Shouldn't it be better that the people who are elected decide this? I mean, do I really want, as a judge, allow someone to have a permit and he goes kill someone? I mean, do you want people to die? Is that what you want? Want people to die? I mean, is this for us to decide?
No, Your Honor. Neither legislatures nor courts should re-engage in interest balancing. That was done at the time of the Second Amendment. The Second Amendment is in itself a product of interest balancing. While it's important to consider the legitimate interest in public safety, that doesn't need to go farther than necessary and impinge on Second Amendment rights.
Okay, you have 30 seconds left. You want to wrap up.
Yes. New York's proper cause requirement is far from narrowly tailored, relegating Second Amendment rights to second-class status and restricting expression of the right to a select few. Courts have never upheld such a regulating scheme and should not do so here. Thus, we urge the court to reverse the Second Circuit's ruling.
Okay, very good. Right on time. Okay, thank you so much, petitioners. Respondents, if you can please come back on camera, and you'll have 15 minutes to make your argument. Whenever you're ready.
Thank you, Your Honor, and may it please the court. I'm Leighton Shore.
And I'm Katie Gutowski, and together we represent the respondent in the case of New York State Rifle and Pistol Association v. Bruin.
At question in this case is whether New York's denial of petitioners Robert Nash and Brandon Coach's applications for concealed carry licenses for self-defense violated the Second Amendment. Today, we argue that the answer to this question is no. There is a right to bear arms in public for self-defense, but it is not an unlimited right. After applying for a concealed carry permit in 2014, both men were granted the ability to use handguns away from densely populated places. Mr. Coach was authorized to carry his firearm to and from work, and both men did not demonstrate proper cause for unlimited carry licenses under New York's licensing regime. And both men were afforded due process because a licensing officer's denial of an application in New York is subject to judicial review, as established in 2002 New York Court Case of Appeals, Bando v. Sullivan. The proper cause requirement in New York's law does not violate the Second Amendment. The 2008 case of Heller instructs that the scope of a Second Amendment right is determined first by text, then by history and tradition. Enshrined in the Second Amendment is the principle of federalism, and this court has a long-standing tradition of giving deference to state legislatures to regulate.
Let me just stop you. So text, right? Keep, verb number 1, bear, verb number 2. What weight would you give this second verb, this verb of bear?
So if we look to the reigning precedent, and that being Heller, we see that Justice Scalia made this distinction between keep and bear. And Justice Scalia stated that after this analysis of history and tradition and the difference between these two terms, there was a core right to bear due to the longstanding tradition of bearing regulations. But there was not a core right to bear, although there was this core right to keep. And the reason there wasn't a core right to bear was because of the harms bearing imposes on public safety.
But this is for Ms. Gutowski. But Heller was only about a right to carry in the home. Did the court really have occasion to decide the scope of what happens outside the home? It seems this was a fairly narrow statute that DC had.
Right, that's correct. The holding in Heller did specifically apply to keeping of arms in the home, which is why we look to the fact that bear is a different right from keep and therefore shouldn't have the same outcome.
Did Heller prevent? Did Heller, I think Mr. Schur said a minute ago, does Heller prevent, or did Heller say anything about bearing not being fundamental? Was that in Heller?
Heller did recognize that bear has less of an ability to be regulated than the right to keep arms in the home, because keeping arms in the home is a core protection, a core part of the Second Amendment. And bear, because of the interest of public safety, is different, and that the natural meaning, it naturally has longstanding prohibitions that have regulated bearing outside the home.
Okay, you may proceed.
Thank you. So, enshrined in the Second Amendment is this principle of federalism, and the court has a longstanding tradition.
So we talked about text, but for history, your brief states that New York's proper cause requirement clearly falls into the longstanding tradition of the Second Amendment. What is your most persuasive precedent on this point? Well, so we see that there is a longstanding precedent of many comparable regulations that we outline on pages 21 to 24 of our brief, most notably those that have prohibited the carrying of arms greater than or to the extent of New York's law, starting with Tennessee in 1821, New Mexico in 1860, Texas in 1871, Arkansas in 1875, West Virginia in 1887, Arizona in 1889, Oklahoma in
Counselor, wouldn't you say the majority of those were discriminatory in nature and armed specific and were targeted specifically at racial minorities and to disarm them? What do you do about that?
Well, I think that was an inherent problem of these laws, but we see that I think it's more important to look at the fact that consistently this court has left the regulation of arms to the given deference to the states.
But isn't it correct that today the vast majority of states, I think only 7 or 8, do not allow their citizens to carry out firearms outside? So the majority of states do today.
Sure, but just because there are some shall issue regimes doesn't mean that may issue regimes are less important or less valid under the Constitution. We see that 9 current states today have may issue regimes other than New York, including California, Connecticut, Delaware, Hawaii, Maryland, Massachusetts, New Jersey, and Rhode Island. And in total, from the founding through the 20th century, 20 separate states have at some point in their history prohibited either the total carrying of handguns in densely populated places or have limited the carrying of such weapons strictly to people who can demonstrate good cause. And so
let me interrupt you, Counselor, and I want to shift gears a little bit, and this question's for Mr. Schur. Isn't it true that one of the petitioners here is able to carry his firearm to and from work? Is that correct?
Yes, that is correct.
Right. And so, but yet he is unable to carry his firearm outside of the work context whenever he's off, right? He can't carry his firearm in that context, right?
Yes.
Why?
So, as Justice Scalia identified in Heller, using the common law analysis made in Young v. Hawaii, we saw that the court recognized the dangers bearing an arm has on the public safety and or ordered liberty. And the reason it's so important to give this deference to the state is because it's a state's choice to choose if they want to value the public safety, the overall safety of their state versus the individual's right to bear this arm. Because many studies have shown, and you can look.
But Counselor, what difference? I struggle to find a difference between when he's going to and from work and able to carry his firearm, and somehow the state's interests and safety are heightened in that scenario versus when he's going to and from a retail store. I don't see that. Do you see the disconnect here?
Well, I would say that if you look to page 38 of our brief, you can see how any appearance of a weapon in public does in fact eventually equate to more violence, more gun deaths. The more guns.
This is concealed carry, is it not?
Yes, but the more guns in a state, the more gun violence there will be. If you look to page 38 of a brief, you can see that there will be an 11% increase in deaths when a state uses a shall issue regime than a may issue regime. And this satisfies the Dalbert standard because we can see that it is a peer-reviewed and generally agreed upon consensus. So yeah, he can bring his gun to and from work because it was found by the officials that there was a need to bring that gun, or more of a need to bring a gun to and from work.
Mr. Schur, look, you have studies, they have studies, Dalbert, however you want to say it, we get experts fighting over this. Didn't Scalia say that this interest balancing has no play, right? That the framers balanced his interest 200 years ago. Who cares what the studies show?
So, and that is why we look first to history and tradition, and we show you that line that can be drawn from common law to American precedent using Heller and some other precedents that have been established before that. But we believe that, as you said, when history and tradition is not fully clear, when there are some states that had shall issue regimes, some states with may issue regimes, that's when we look to this interest balancing approach.
But isn't that the sort of rational basis scrutiny that the Heller court rejected? You're doing what Breyer did in dissent. I mean, that was the Breyer dissent. This is from Skotowski, right? It seems like you're favoring the Breyer approach, and he's gone. He's meant to see pina colada soon. I mean, what Why are we doing that?
Well,
Well,
we
we're
believe,
From Mr.
sorry.
Kowalski.
Yeah.
Yeah.
Right. So what we're doing is we're trying to be consistent with what the history and tradition tell us. And we're looking to intermediate scrutiny because we can see that Bear should not be considered fundamental. And it's comparable to substantive due process and corporate speech as these things that are enumerated in the Constitution that still are also not viewed as fundamental because there's a government.
But the Second Amendment says bear. I think you're only focused on one of the verbs. But this is not substantive due process. It's not penumbras and emanations. This is right there.
Well, I think that there's a really important distinction that we have to make in the founder's intent of keep and bear, first of all, because bear and keep are two very different things. And they, before the Constitution, were not standardly even used together. To keep meant at the time to retain and not to lose, to have in custody. So we see how that translates to Heller ruling. That means to possess weapons in the home. But to bear's natural meaning was tied to referring to carrying weapons outside the home. And the fact that these two things are so different means that, contrary to Justice Stevens' dissenting opinion in Heller, the phrase keep and bear arms was not meant as a single term applying only to militias, but that these rights to keep and to bear are different rights. So they should be treated differently. We should rule on them differently. And I also believe that the counsel for the petitioners agree with us on this point in their brief, which is why the reason Heller should not solely determine the outcome in this case. If that answers your question.
Thank you, Councilor Key. Maybe you guys may proceed.
So we believe that we should use intermediate scrutiny based on precedents such as Kachowski and a few other lower court decisions. And we believe
Counselor, real quick, where's that out of? What circuit is that case from?
Kachowski v. County of Westchester. I believe that is
Second.
Second. Sorry.
Ninth Circuit?
Second. Got it. So the government interest to protect public safety is inherently greater in public cases than the home. And we see that New York's law satisfies intermediate scrutiny because it is substantially related to the interest of ensuring public safety, especially in these densely populated areas. And we also give you this empirical evidence on page 38 of our brief, as I mentioned before. Due to the fact that Heller identified the Second Amendment's power to create security, not just of a free state, but of one's person, a scientific consensus satisfying the Daubert standard can help this court to evaluate if a law promotes the goals of the Second Amendment, this being the security of a free state. Now,
is this really the role of courts to be balancing statistics and constitutional litigation? I mean, why? You have experts, they have experts, and we can fight about Daubert till the end of time, but why does this factor into our decision? I mean, how is there some number of deaths that's acceptable? It's like, oh, okay, that's enough deaths. I mean, what are we even judging this based on?
Well, that is why we believe the deference should be given to the states, because you're right, the court cannot make this uniform decision saying, you know, this amount of deaths is acceptable, this regime is acceptable. But we believe that integral to the Constitution is this value, this idea of federalism. It is up to the state to decide how they want to balance public safety with this right to bear. And that is where the research comes in. That is why we must use the Daubert standard to evaluate this research. In doing so, if we look to some of the research presented by the petitioner, we see that a lot of it doesn't satisfy that Daubert standard. So while the court can then say that they want to protect this right of the people to bear, while at the expense of a citizen's right to security.
But maybe a question for Ms. Katowski. Rights are dangerous. For example, the exclusionary rule, right? If you seize evidence without a warrant, the bad guy goes free, right? If you don't give a person the Miranda warrants correctly, the bad person goes free. People can advocate for violence. If it's not imminent, that's protected speech. A lot of our rights are pretty dangerous. You know, why is the Second Amendment different from all other dangerous rights?
I don't understand. Could you please rephrase that question?
Sure. A lot of rights can yield social costs, right? For example, if a police officer doesn't give Miranda warnings properly to a suspect, his confession is excluded and he goes free, right? If the police seize evidence without a warrant and the evidence excluded, the criminal goes free, right? If the jury is not properly selected, the bad guy goes free because the trial gets reversed. There are lots of dangerous rights. Why should the
Right.
Second Amendment be treated differently than these other dangerous rights?
Well, we believe that we can look to the First Amendment as a way that as a model for how we can judge this, and it can guide us in determining what regulations would be allowed under the Second Amendment. And this court has long allowed for limited speech for reasons of public safety, recognizing that the government has a stronger public safety interest in regulating the labeling of food than it does in the content of political or religious speech. All you have to do is look to the Caroline products that established strict scrutiny to see that, and it's for the same interest in public
Well,
security.
can I interrupt you now that you mentioned strict scrutiny? If we apply it, do you lose here?
No, we believe that even under strict scrutiny, we believe that this is narrowly tailored because the right of a citizen to protect themselves with a pistol is a pre-existing right crystallized by the Constitution, but it does not and never will hold more weight than the interest of public safety. And so because New York's law is consistent with the text, history, and tradition, it upholds the principle of federalism and ensures the interest of public safety. We urge a decision in favor of the respondent.
Thank you so much. All right, I'm going to stop the timer. If the petitioners come back for their 5 minutes rebuttal. All right, whenever you're ready.
Thank you, Your Honor. Respondents contend that the right to bear is the right to carry is less fundamental than the right to bear arms, the right to keep arms. This court said the opposite in Heller. While the right to keep arms may be at the core of the Second Amendment, the court specified that the freedom to carry, in the case of confrontation, was also a fundamental right, not a second-class one, as the Second Circuit said in Kachowski. As First Amendment case law tells us, freedom of the press is no less central to the First Amendment than the freedom of religion. In the same way, a hierarchy of rights cannot be created in the Second Amendment. Any restriction on the right to carry must pass heightened scrutiny, just as any restriction on the right to keep arms must do so.
So let
Counselor.
me, oh, I'm sorry, Ms. Justice
Go ahead.
Wallison. Please go ahead, Justice Wallison.
So you previously said that the New York should not adopt limitations such as the good cause standards because they infringe on the Second Amendment rights. What limitations would you suggest should be in place in order to be approved for a concealed carry license?
It must be an objective standard. Perhaps New York must ensure that all applicants demonstrate that they have gone through safety training courses or that they have no criminal history. A long-standing prohibition on the ability of felons to carry firearms is constitutional under the Second Amendment. Or perhaps that the only restriction that we see as unconstitutional is any restriction that only allows people who demonstrate an atypical need that separates them from the general public, the regular person, to exercise their Second Amendment rights.
So Ms. Young, let me ask you a question, please. What do you do with all this expert evidence? Mr. Ashur says you have all these statistics showing that more guns, more crime, people are dying. How do you handle that sort of mountain of empirical evidence?
I believe there is disputing information on this, but we can look to the 40-some states that are shall issue or unrestricted, which have not had
I get that, and I live in one of those states, and everything seems pretty cool here. But Ms. Katowski says that there's no requirement that a state must be shall issue. How do you respond to that argument?
I believe there is a requirement that the standard should be set and allowing the general population to exercise their Second Amendment rights. So I'm uncertain how a may issue regime, which allows officials total discretion over how to issue a license, could be constitutional under the Second Amendment.
And then maybe from a Spanner, what happens if we rule in your favor and New York sees a surge in gun crime and all these dead bodies piling up on the street? How are we supposed to react to that?
Well, there's disputing evidence over whether that result will occur.
Well, let's say it does. Let's just hypothetical, right? We issue this ruling, and 2 years hence, New York come back and says, "Look, we have all these dead bodies. Want to reconsider?"
We don't believe it is the court's place to weigh whether to again re-engage in interest balancing. Even the legislature has limited ability to do that. However, we believe that if there is an increased demonstration of public safety, there could be an argument for that. However, again, even no matter what the effect is, there cannot be a carry regime that only allows people with proper cause to exercise their Second Amendment rights, no matter what the consequences are.
So all these people getting permits is gunning everyone down the street, right? They no criminal background, but they decide, oh my God, I have a gun. Let me go to massacre. We got to just stand by.
Could I say something?
Please, Ms. Young, go ahead.
We do have cases like State versus Huntley and State versus Simpson, which prohibit carrying in a terrifying manner. So New York could restrict that terrifying manner with those who carry with evil intent.
But once
And
the person
also
has the
for-
gun, it's too late. They're going to just go pow, 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 and well, they have the gun.
I believe those who have the tendency to create crimes. There is a long-standing restriction that felons can be restricted from carrying arms. So I would say the vast majority of these people who were leading massacres would fall into this category and prohibited from carrying arms.
That's probably true. All right, you have 20 seconds left. You can wrap up.
Respondents have given examples of 19th century case law and 20th century case law that to defend their regime. However, many of these laws are now defunct under Heller or were discriminatory in nature, and many of them aren't even comparable to New York's regime, which restricts what is a fundamental right to those with an atypical need to express it. That is unconstitutional under any measure of heightened scrutiny. Thank you, Your Honor.
Okay, very good. All right, if everyone come back on camera, please. Oh my goodness, that was good. I think that was one of our best rounds yet. Probably top 2 or 3. I mean, my memory's blurring. That was really good. Both teams went above and beyond what we expected. What I loved, and not just like, what I loved was how deep both your researchers was. You're citing cases, right? You're citing statutes. You're rattling up on page 18 of our brief. You're saying in Oklahoma in 1875, my goodness, you had command. You're talking about the Daubert standard. I say Daubert, maybe just Bryce says Daubert. I don't know. Reed, what do you guys say? What do they teach you in evidence now?
I say Daubert.
I learned Daubert. What the hell do I know?
Lauren Daubert.
Yeah. So what do I know? But you didn't flinch when I asked you a question, right? Do you want people to die? Right? You didn't flinch. You sort of said, oh crap, and you answered my question. Right. I was asking you some really hard, like I have different levels of questions, and I pulled into my back drawer for this round. Right. I went to my harder questions, which I don't always raise. That was spectacular. I know Leighton and Katie did this last year, but Elise and Audrey, this is your first time. You could walk into a law school tomorrow and like win a competition. You could walk in tomorrow, win a competition. You're 16, 17 years old. I hope you make your way to law school at some point, because it'll be a loss to the profession if you're not, because there's so much you have to offer the world with just your ability to have the recall and the pivots. There was no discomfort, right? We were throwing bombs at you and you're just like a fly swatter, just knocking them away. So truly, that was a remarkable round. You should go back and watch this on YouTube later, but it was real good. Ashley and Reed, I'm gonna shut up now.
No, I completely agree. Y'all did so good. There's 2 things in particular I noted that I really liked that you did. So the first thing is you took time to breathe after you got the question instead of just completely attacking it. So I think your answers were more well-rounded that way. And then if there was a question you didn't really understand, instead of kind of just free throwing your best answer, you asked to like rephrase it or repeat it so you could give a better answer. And that was really good. The second thing, which Professor Blackman noted, was y'all did really good at citing sources and specific pages in your brief. I think that really shows us that y'all are well prepared and knew what you were talking about. So I just think y'all did really good. You were even citing cases such as like Caroline Products, which I know it deals with strict scrutiny, but I didn't know about that till I took con law. So y'all are way ahead of high school. Y'all might be ready for law school at this point, haven't even gone to college. So I think y'all did so good. The only thing I would say at times is, I know, you're on a timer and you have a lot to get out at the same time, is maybe just slow down a little bit. And it's something I struggle with every day. So, everybody's in the same boat, but y'all did really great.
That's such good advice. So I'll give you just a tip that I use: breathing. And a couple of you did that, but when you get a question, just take a breath. It might feel like you're waiting an hour, but just like a half second, and that breath helps you. And when you get to the end of a point, breathe. And the reason why is when you create these sort of gaps, you give the judge an opportunity to jump in, and that creates less of a crosstalk, right? You want us to interrupt you. So leaving these sort of deliberately placed breaths creates that silence that Ashley or Reed or myself can jump in and sort of redirect you. But what we're describing is like a high level skill, but that's why we're giving you advice that's like next level stuff. Reed?
Yeah, no, I want to let you know I wrote down excellent like 50 times and wow several times because these were honestly some of the best answers to questions that I have seen in all these rounds. They were next level. That being said, I'm going to give you next level advice because this is the only critique I think I can, other than the slow down one, is it's what we call in the business front loading questions, right? So if I ask you which laws or which pieces of history support your position, right? And you go on this expose about, well, in the 19th century there were several laws, blah blah blah. Okay, yes, you're going to eventually get there, and then at the end of the sentence you say, well, the laws from Mississippi, Tennessee, et cetera, et cetera, et cetera. Instead, flip it. Put, well, the Mississippi law from 18 whatever, 19 whatever. Put the actual answer at the front because we're impatient and we want to know what actually supports your position first. You see what I'm saying? There's a difference. So put the answer at the front and the justification at the back.
Yeah, that was excellent. I mean, look, we've done the 8 or 9 rounds already, but that was just really, really solid. I always like to pause here and let the students ask us questions, either for me or for Ashley, for Reed, whatever you have in mind. Anyone, who wants to ask a question? You're all bright, all very bright.
I mean, I'm not sure if you're even allowed or supposed to answer this, but am I allowed to ask like your kind of not like with the law backing side to it, but your opinion of this case? Obviously, yeah.
Yeah, you know, I mean, other students have asked me that same question, so you're
Okay.
saying. I mean, I think New York is probably going to lose. I just don't know how they're going to lose.
Interesting.
It's a really tough question, level of scrutiny, because depending what the court says here, it affects other cases. So if you say strict scrutiny, okay, then what about felon disenfranchisement laws? What about all these other types of regimes? If you say intermediate scrutiny, well, that sounds great, but the lower courts have basically upheld every single gun control law under intermediate scrutiny, which is nothing. It doesn't do anything. I don't know what the court does here. There's also a question which I was going to ask you, and I didn't get a chance to: open carry versus concealed carry. There's a much stronger argument in favor of open carry than concealed carry. So one of you mentioned Hawaii case. Was it Young versus Hawaii?
Yeah.
Leighton mentioned it. That one is waiting in the wings, and that's an open carry case. There's a non-trivial chance, which I flagged, that the court might not decide the New York case at all this year and say, we'll do an open carry case. Because I think
very interesting. Thank you.
Yeah, I don't know. You're like the third person to ask me this question so far in the tournament. I don't have a good answer for you, but I think New York loses. I just don't know how. Or the court can say the lower court applied the wrong standard, go back and reconsider it and do absolutely nothing.
Got it.
Which is basically what the court might end up doing. Between abortion and everything else going on, they may just decide not to do it this year. Just kick it till next year. What an exciting time for you guys to be students. Just there's so much flux going on. Just it's very exciting. I mean, I'm dating myself, but in 2008, when you were all in diapers, I was a law student, and I was actually for Heller. I was a research assistant for the Heller amicus briefs, Professor Nelson Lund. So I was a law student when Heller was decided. So it's like a lifetime ago. We're still waiting to see what it means. What other questions you guys have?
One thing that Elise and I had some trouble with was the sensitive places doctrine.
Yeah.
Just approaching that.
So did you guys listen to the oral argument with Paul Clement at the U.S. Supreme Court? He had trouble with it too, didn't he?
Yeah, the whole New York University thing was comical.
I knew you knew what I was talking about, so I didn't push it.
Yeah, I was like, he's just asking what they asked, and I was like, how did Clement respond to this? And I'm not going to do it as well as he did, but I was like,
I thought he did a not awesome job. But I mean, that's actually a fair point, right? Paul Clement is one of the top lawyers in the world, right? He's just, this superhuman. And he didn't have a good answer to the question. So you think you're going to have it at 16 or 17 years old? Come on. But it's often going to be the case when you're a lawyer and you don't have a good answer to a question from a Supreme Court judge. You just don't have a good answer. You don't have a good answer on the law, and you don't have a good answer on the facts. And it's one of those rare times where you have to sort of tap dance. Right, Reed, what did they teach you in court where like you just got nothing and you got to say something? What's the advice you give to this to the students?
Yeah, usually when it's some sort of bad hypothetical, you try to answer it to the best of your ability, and then you say, but that's really not what we're dealing here. That's not the case here. And then you try to get back to what we're dealing with here is X, and you try to get them back to your outline. But try to answer it because if the judge draws you back, well then try to do it again. But they're
Look,
going to want to drag you.
If like Justice Kagan or someone's pushing you, you're just gonna have to suffer, and it's gonna sound awkward. I mean, if you listen to Paul Clement, you know what I'm talking about, right? With the New York University campus, it's like he was, if you think of a boxing match, right? I don't know if you ever watched boxing, but sometimes in a boxing match, the boxer is just going to take some punches, and he's just going to take the punches, let the other guy get tired out of it, and then come back later, right? So sometimes you got to take your blows and just get punched. Don't get knocked out, right? Don't go to the floor, but you got to take some punches, and it's going to be ugly. It's not going to be graceful. But Reed, I think fair advice. You pivot as quickly as you can to a strength, but the judge says, no, I'm not done yet. And it's like, oh, come on, I'm almost, yeah. And then we drag you back in. I did a little bit of that today to try and, but I let you go. Because when I say you can proceed, that's me saying, okay, now you go back to your routine. But I did want you prepped for that. But yeah, the sensitive places question sucks because there's no good answer. I didn't get to the entire island of Manhattan, right? What do you do with that one? I usually ask it to the other side. I didn't ask it to this side today, but the entire island of Manhattan, right? All there are kids everywhere, right? Or I can ask a variant, someone said school zone. I didn't do this because I didn't have time, but if we say within 500 feet of a school, all of Manhattan's covered because there's schools everywhere in Manhattan, right? There's nowhere to go. There's a school everywhere in Manhattan. They're everywhere. In a dense urban area, if you're within 500 feet of a school, there's nowhere. So it's basically the entire island of Manhattan will be sensitive. So look, I can go many different directions, but your pivots were strong. And I felt bad for you, Lisa. I can tell you were like cracking, your voice was cracking. Do you have water or anything nearby?
Oh, I was fine. Yeah, I feel like, I don't know, I'm up at like my grandparents and it's like different altitude, I feel like, and I don't know, it's just like messing with me, but I'm good.
Okay, good. I saw your voice was cracking. I felt bad.
Oh, it's all good. Don't worry
Usually
about
it's
it.
Zoom,
I
but
felt bad. I was like, oh gosh.
yeah, no, but that's not your own fault. All right. What else you guys have?
Just on like a purely procedural note, like, so there's how many more rounds after this if we do advance?
Correct. Right. So this was a semifinal round. If you advance, we have the round of 8. So there'll be, and that will be the 26th or the weekend of the 26th, the weekend of March 6th. So we have a couple weeks, and then we're going to do a final 4. We haven't done that before. So we're going to have a final 4 and the championship round. I hope we can do the championship round in DC. COVID's looking good, right? I don't know your preference for travel, but come April, I think travel will be okay. I hope, God willing. I don't know. The only wrinkle is Georgetown, not a wrinkle, but Georgetown, it requires either a vaccine or PCR. So I mean, we can work around that. But that's the short answer. So there'll be a round of 8. So basically, this was the semifinal round had 13 and 13. Next one will be 8 and 8, and then anyway, they'll move on. Okay. All right. What else? All right. Well, we have another round coming up. Thank you so much. If the students please sign off, we'll do our grading, and we'll hopefully see you very soon.
Thank you guys very much for taking the time to do this.
Oh,
Bye.
my pleasure.
Yeah, thank you so much. We really appreciate it.
Thank you. All right. Take care. If you have any information, any questions, feel free to email me.
Great. Thanks. Have a great day, everybody.
Bye-bye.
Thank you.
You too.
Let me turn the recording off.